I will try to share with you some short reflection on the international system of human rights protection that may appear theory, but in fact are going to be more probably practice. International law is important too and shapes many aspects of international relations between the states themselves, between states, their own citizens, and between the international community, states and individuals. I would like to propose that one of the most influential and recent contributions of international law in promoting human rights is its potential to ensure accountability of the states, of the international community, of individuals for compliance with human rights and international humanitarian law. Accountability exists when states, institutions, and individuals answer for what they are held responsible for, and this includes taking ownership for one's actions and accepting the consequences. Accompanying the development of international law, there has been an evolution of accountability on many levels. Initially, international accountability was implemented only in state-to-state relations, as international law was meant to regulate only interstate activities. Next, international accountability was implemented in states' relations with individuals, and most recently has been recognized on individuals by the international community. I maintain that such evolution has been largely influenced by the division of the rules of international law into two large domains and the role assigned by them in each of these domains to human beings. Let's go quickly back to the beginning. In 1625, Grotius published his famous book, De Jure Belli ac Pacis, The Law of War and of Peace, which is regarded as the first comprehensive treatise of modern international law. As the title of the book itself shows, its author regarded international law as comprising two distinct bodies of rules, the rules to be applied in wartime and those applicable in peacetime. This distinction reflected a common view of the then legal community that on one hand it rested on the consideration that a single body of rules was inadequate to regulate peaceful and friendly relationships between states, and at the same time those relationships when a war had broken out between them. On the other hand, the distinction reflected the idea that war and peace were both normal situations in the life of states, which had to be given equal weight and legitimacy. Admittedly, the entitlement of states to go to war to settle their international disputes tended to be restricted under the emerging doctrine of the just war through the availability of justification to go to war. However, a declaration of war was not, in principle, accompanied by a negative connotation when a state could invoke a legitimate claim against another state. While a peaceful settlement was described by Grotius himself at the time as desirable, no international rule imposed on any state the duty to abstain from using the force to see its claim satisfied. Now, this approach, with some distinctions, with some developments, continued to be the approach of international law for centuries, until the Second World War, essentially. You find still in last century literature treaties, important treaties of international law, divided into books: the law of peace, the law of war, two different domains of war. And the distinction remained until war was banned as a means for settlement of international disputes by the Charter of the United Nations. But what is interesting to note for our purposes is that the protection of human beings as a matter of concern of international law started being felt in the field of the law of war, not of the law of peace. what states could do in their relations with their citizens and their territory was not a matter for international law. It's only in the field of the law of war, some in the 19th century, some principles of protection of human beings became principles applicable and principles recognized by the international community. Now, when the United Nations Charter was adopted, what happened of these two fields of war, of law, as the war was banned as a matter for, as a means of resolution of international disputes? In fact, what happened is that those systems went on and developed separately, distinctly. The law of war continued to have its own tenants, its own lawyers that were dealing with this field of law, and the law of peace continued to have their lawyers dealing with the war of peaceful relations between states. The point is that by virtue of the United Nations Charter, the big ban was that human rights were recognized as a matter of concern for the international community. So the interest of international law for human rights in peacetime arose much later than in wartime. It was already a matter of concern starting with the Hague Conference of 1899 or 1907, but in peacetime was just a matter of concern as of 1945 with the Charter of the UN, and later, as you know, the Universal Declaration and the many, many conventions that were adopted both at the universal and the regional level. And I will not dwell on these aspects. Now, what is the relationship between the two fields of law? Is that justified to have two systems of law today, or more than justified, is that what happens in international law, that we have two systems or we have one system concerning the protection of human rights? Is human rights law and international humanitarian law are two separate bodies of fields of law, two systems, two different systems, or are they merging and being essentially one system, so that the old traditional separation does not make much sense? I maintain that in my paper that the two systems are no more one system. In fact, what are no more two different systems, but they are merging in one system. In fact, how did the doctrine and the jurisprudence deal with the two fields of law? Let me go to the most authorized source of jurisprudence in matters of international law, that is the jurisprudence of the International Court of Justice. The International Court of Justice had to face the problem of the two fields of law and initially resolved it as a matter of general law and special law. General law would be the law of peace, and in particular, in our field, human rights law. Humanitarian law would be a special law applying when a situation of war emerges. Here there is already a difference as with the traditional, because speaking of one field as general law and the other as special law gives more weight to the general field, clearly. The other field is a special, so has to be interpreted restrictively and derogates from the general only following a narrow interpretation of the special field, clearly, when clearly there is a derogation from. So it's quite a difference as compared with the initial position that the two systems were equal and had equal weight and were both having the same legitimacy. However, it is clear that if we speak of derogation from one system in favor of the other system, we still have two systems. One is applying, the other comes in when the one does not apply because of a derogation. And this was the initial position. More recently, the view of the International Court changed slightly. In the opinion on the Palestinian wall, this approach was modified, and the ICTY came to the conclusion that human rights law applied also in time of war, but subject to the derogations from its provision, not by virtue that there is a war, but by virtue that there are derogations allowed, admitted in the system of human rights. And the reference to Article 4 of the Covenant on Civil and Political Rights, to Article 15 of the European Convention, 27 of the American Convention, is clear. The systems of human rights allow for a possibility of derogation, of suspension of rights when a situation of emergency arises, and of course the typical situation of emergency may be also a war, not the only one, but certainly may be a war. The wording of this convention, even the Covenant does not speak of war formally, but speaks of emergency that threatens the life of the nation. So essentially is a situation of conflict. So even the court continues to consider the relationship between the body of law, which is human rights law, and the body of law, which is humanitarian law, as being regulated by a system of derogation, which in a way is not the same as the old tradition, but more or less remains within the same system. I maintain that this does not seize completely the problem. The problem is not that there are derogable rights and non-derogable rights. There are. In the Covenant, in the Convention, there are rights that are derogable and rights that are not derogable. The provision on derogation spells out the number of rights, the type of rights that can be derogated from. But this is not the main issue. The main issue is that there are rights that are absolute and rights that are not absolute. If one reads the conventions on human rights, some rights are described as not admitting any attenuation of the right. Other rights are described as admitting some attenuation, some limitations, some restrictions for particular reasons that are public policy, national security, protecting the freedoms and rights of others, because sometimes one has to weight one right against another right. Now, the real problem is that one. And when one looks at derogable rights and non-derogable rights, it doesn't mean that all the non-derogable rights are absolute. They may be subjected to restrictions. So the system of human rights allows for limitation. The only problem are the rights that are absolute. But if one looks at these few rights that are regarded as absolute, freedom from torture, for instance, recognition of a person as a human being, these apply equally. They are protected both by human rights law and by humanitarian law. There is no difference between the two fields of law. So if we restrict our consideration to the limitations, to the rights, most of the rights which allow for restriction and limitation, we come to the conclusion that you can always apply human rights law, because it's clear that the limitation, for instance, for reasons of national security, will be different in case you have a war, or you have a strike, or you have another turmoil in the country. So, in fact, you can continue to apply human rights law all the time. Simply, the rules that you can bring in may be different in case in which there is a war. Even the most, what has been considered the most objectable point to this common application, that is the right to life, in fact, allows for restrictions. The right to life is not unlimited. It is one of the non-derogable rights in all the conventions, so it cannot be suspended. But the scope of the right is not unlimited. The covenant is quite clear. It says nobody can be arbitrarily deprived of life. Yeah, but that word arbitrarily is a limitation. It means if it's not arbitrary, a person can be deprived of life. Human rights law does not exclude that. It's true that this rule was put in the covenant essentially to allow, to recognize the possibility of states of keeping capital punishment. But in fact, the human rights bodies, including the Human Rights Committee, have made application of this arbitrary in other situations. For instance, use of firearms by the police. All the policies can make use under certain conditions of firearms. Maybe arbitrary or not arbitrary. It depends from the law. It depends on the law to allow for use of firearms only when this is not arbitrary, when this is legitimate, when there is a law providing for it, and when it's justified. But in fact, this word arbitrary allows for limitations. And it's clear that if you have a war, the limitation is that combatants can be killed, not civilians, because the law doesn't accept the killing of civilians. But combatants can be killed because of the war. This is part of the military operations in case of war. So the system tends, in my view, to be unified. But my last remarks are on accountability. Let's come to accountability. How this system of accountability is shaped. The two systems went their way for a long time. The system of human rights in peacetime, so the human rights system, as you know, I don't have to explain it here to competent experts, is a monument of machinery. The United Nations, the regional organization, created a huge machinery to ensure compliance with the principles of protection of human rights enshrined in the conventions. And the target of this has been essentially the state. All the monitoring systems go to the state, not to the individuals in human rights law. It's just the state that is considered accountable for protecting the human rights, and the mechanisms are aiming at ensuring compliance and recognizing, declaring, establishing accountability of the state vis-à-vis the individual. And there may be reporting system, individual procedures, courts of justice. There is a lot of development in this regard. The individual remains out. If the individual commits a crime, if the agent of the state that violates the right is the one recognized as having violated, is the state responsible. The system of human rights doesn't go to the individual. It's for the state to take action against the individual that materially has committed the violation of human rights. On the other hand, humanitarian law went in another direction, went more on recognizing the responsibility of individuals. Even the Geneva Conventions of 1949 provide that states have to criminalize the grave breaches of humanitarian law, of the conventions, and leaves it to state to do that, but imposes on state an obligation to criminalize the violations. States did not do that. Many states did not implement the Geneva Convention in that respect. At a certain moment, the international community jumped in and decided to do it itself. So brought the jurisdiction to the international level. But that was done in the field of humanitarian law. Even Nuremberg provides for cases of very few of crime against humanity, but provided that these crimes are in connection with the conflict. The statute of the ICTY says the same, provided that there are crimes against humanity, but they are punishable only in connection with the conflict. So it was the system of humanitarian law who brought about this development. Things are changing. The statute of the ICC does not put the condition of a linkage with the conflict. Means gross violation, grave violation of human rights are punishable under the statute of the ICC. In a way, the statute of the ICC provides for a system, a common system for human rights law and humanitarian law. So we have, under the umbrella of jurisdiction, a unified system also from the monitoring point of view. But there remains gray areas because for the responsibility of the state, humanitarian law doesn't provide for any mechanism. And human rights law provide essentially machinery targeting the accountability of the state. There is a new development. It is felt, but this is matters of days now, there is an initiative taken by the ICRC, the International Committee of the Red Cross, together with the Swiss government, to establish a machinery for monitoring compliance with IHL. And that will be based on meeting of the states and a reporting system, a system of reporting and a system of fact-finding, thematic discussions. But this is very similar to the human rights. It's presented as a new invention. But in fact, the human rights system is essentially based on reporting, is essentially based on thematic rapporteurs of situations, fact-finding missions. Sometimes, in the case of the Convention on Torture, there are fact-finding missions, for instance. So nothing really new, but the idea is to have a system of compliance, monitoring compliance with IHL, parallel to the system of human rights. And that would bring, at the end, that together will be justified to have two machineries, or at the end, one machinery will be enough. I don't know what the future will be, but it's obvious that these systems are, from the legislative point of view, merging. If the machineries are parallel, at the end, even the simple idea of saving resources and having a coherent system will bring to have one system of monitoring. There is one aspect that this initiative does not take into account, but they should be taken into account, in the human rights system already exists, is that for ensuring compliance prior or during the commission of the violation, one has to do without a system of criminal law, has to invent something else. And my idea, my view is that one should strengthen a system of provisional measures. They exist in human rights law. They can prove to be very effective in certain situations. The committees of the United Nations have applied provisional measures and imposed provisional measures. They worked in a number of cases, and one should shape some mechanisms of provisional measures also to protect, to ensure compliance with international humanitarian law provisions. Well, these are in, I wrote more, but I will share that maybe later with all of you. Thank you for your attention.